session. The Honorable Mark H. Jones, Judge presiding.
Okay, good morning. Please.
Good morning, Judge.
Okay, State versus Franklin Tucker, 2017 CF 841. Everyone's here. So are we ready to proceed with the defense evidence?
Good morning, guys. They are starting right on time. Good morning, Lee. Good morning. So I'm doing the morning stretch. Oh, goodness gracious. He is there. I know, right, Lee? He's ready. He's ready, Freddy. So yeah, I'm eager to see how this morning's going to go. I'm going to go ahead and push play and get this ball rolling. But good morning. Anybody coming in? Looks like it's me and you, Lee. For now. Okay, I'm going to go. Press go.
No, Your Honor, I filed a motion for continuance based on the disqualification of the file.
Could you elaborate, please?
Well, I filed a motion for continuance because the was it a 2.330 of the Judicial Administration? It gives you 20 days to file the motion for disqualification, and in order for it to be procedurally sufficient, it's going to take a little bit of time because it requires service, etc. So I took and I asked, again, I put in a motion for continuance for 10 days, which is half the time to get it ready.
State.
Judge, we would object to that. We are here. We have a jury waiting for us. The state is prepared to go forward. And at this time, that would be to us a fabricated delay, and we would object to it.
Yeah, the motion is denied.
No, Your Honor, if I may be,
Sir, I heard what you had to say. Is there some rebuttal
Yes,
argument?
there is a rebuttal. It actually does say during trial that yes, this still is applicable, and that yes, because I am afraid of not getting a fair trial, it seems like denying the motion and not allowing me the time to file the motion to disqualify would just be a way of circumventing the motion to disqualify.
Denied. So, you ready to present evidence this morning?
No, Your Honor, because again,
Okay.
and don't get me wrong, I did go ahead and, I got the Chief Justice involved with this, just to make sure that we can get this, cleared up without as little as more, what's the word I'm looking for? But the thing is, Your Honor, the idea that I'm going to get a fair trial at this point when I'm not being allowed to present a defense, you already told me that you're not going to allow me to call Todd O'Quinn because you won't issue an order for me to get him here. Yeah, I mean, there's no chance of me getting a fair trial.
I'm not going to go and rehash what happened yesterday. There was never a motion submitted nor pending for such relief. So in any event,
Your Honor, you said you wouldn't give it to me.
In any event, sir, so you do not have any of the supposed witnesses that you were instructed to have that you said you were going to have today?
Your Honor, after...
Sir, I'm just asking you a straight...
I'm giving you an answer here, sir.
Mm-hmm.
After what you told me yesterday, I called those witnesses and told them no. You don't have to come to court today because, again, Your Honor made it very clear that you weren't interested in my witnesses.
Okay, State, you have some response to Mr. Tucker's defiance of the court's instructions, his lack of preparation.
I think the court's been more than indulgent for his requests. The court never denied him anything yesterday. He's got no witnesses to present. The state would request that we keep moving forward.
Okay.
If he's going to rest this morning, Judge, the state does have a rebuttal case that we're prepared to present.
Mm-hmm.
I want to go ahead and...
Well, when you say if he's willing to rest, I didn't hear anything to that effect.
Okay, well, at any rate, Judge, depending on where we go today, if we're able to get to it, the state does have a rebuttal case to present, narrowly tailored to the evidence that was presented by the defendant yesterday through Paula Belmont's testimony. And as far as the defense witnesses, I have no Your Honor's put them on notice that they should have been here today. And if they're not, we would request that the court continue moving forward with this trial.
So, any response to that, Mr. Tucker? Because
Your Honor, again, you made it very clear yesterday that you even went as far as to say you didn't care what I had to say. So, I mean, the idea that, I was going to have those witnesses here and ready to go in lieu of yesterday. I mean, if you would like to give me a day to get them here, sure, I can get witnesses here. But the thing is you made it very clear to me yesterday that you weren't interested in that. And if you are interested in letting me present the defense, I'm more than happy to.
in any event, I'm looking for any input from the state because he was told to have the witnesses here. He doesn't have them here.
So I can even tell the court, the witnesses that he wanted to bring in today, I don't believe are even under subpoena.
Mr. Walker and Lieutenant Scaviglia, their subpoenas were expired, but they were willing to come in today to testify. And the defendant, it's our understanding the defendant called them off, told them not to.
Okay, so
That's
okay, so you don't want to present them?
no, I do, Your Honor, but
Well,
I need to be able to do it, Your Honor. I mean,
sir, you've had opportunity, so
I mean,
you're
if I may make a judicial notice, then again, I am objecting to moving forward, and I'm being forced to.
Yes, sir. You announced ready for trial. You've been given ample opportunity to present your witnesses.
I don't think
and
so.
you have apparently decided you didn't want to.
I was told, Your
so
Again,
we
I was
sir,
told
I know
not to.
you're going to repeat the same things, and that's fine. But
Okay.
at this particular point in time,
If you're going to force me to go to close, I mean, again, it's a mistrial.
excuse me, sir.
It would be a mistrial, Your Honor.
Sir,
You're not allowing me to provide a defense.
Sir, you can state and twist and spin whatever you'd like to. The fact of the matter is there's a clear, unequivocal court order that you have your witnesses ready to go, that you refuse to abide by it. So that's
I'm
the
sorry, Your
bottom
Honor,
line. And
maybe
I'm
I
not going to
misunderstood.
really argue with you
No,
anymore,
I mean, Your
sir,
Honor,
because
was it a written order, Your Honor? Because I haven't seen
it was verbal, just like
Maybe I misunderstood then.
no, sir, you didn't misunderstand anything. You said, in fact, I'll have the motion to disqualify. Okay,
Yep.
you don't have the motion to disqualify. I said, have your witnesses here. So in any event,
It would have been
I'm not going
procedurally
to argue
insufficient.
with Mr. Tucker. So,
Okay. Your Honor,
any-
again, I'm going to have to file an appeal on this decision. Then.
sir, file whatever relief you want to see.
I
That's
do.
all part of the process. But in the
This
meantime,
is a railroad.
we're going to go forward with the trial in one fashion or another, so I'm just looking for some input from the
Sure,
state.
Judge. So just so the record is clear, Your Honor had directed the defendant to have his witnesses here yesterday. We got through Ms. Belmonte, the other witnesses weren't here. Your Honor gave the defendant, he said he'd have them here today. They're not here today. The state would request that we go forward. If the defendant isn't going to present anything else, then the defense needs to rest and the state plans a rebuttal case.
Okay, so I'm going to take a moment to reflect on these developments. I believe I told the jurors to be here at 9:15, so I will reflect upon it and be back in a few.
Yeah, I heard that railroad statement, Lee. Oh my God. How are they gonna? I just don't know what they're gonna do. How do you move forward? I guess the judge is gonna be like, talk about stuck between a rock and a hard place, right? What do you do? I don't even know. I don't even know. But we knew it was going to be like this going into today, right? The railroad comment was waiting on that. I was waiting on him to come out with that comment because, you know, he probably does feel like he's being railroaded. But he should have had his witnesses ready. Better to have them there and not need them than to need them and not have them, you know? Saying that the judge would not accept any witnesses when he only said one was not needed. Yeah. I don't know. Jury, though, what are they going to do if the judge comes back in there and calls the jury in and says, folks, go home? I mean, wow. The jury doesn't know if they're coming or going. I don't know if they're coming or going. Mm-mm-mm. Crazy, crazy. Ay, ay. You feel like he's being disrespectful, Tammy? See, I don't. I feel like he's just done. I mean, don't get me wrong. I feel like he's. I mentioned that yesterday. I feel like he's biased, but also I feel like he's being as lenient as he can without just bending over backwards, you know? Lisa, because everything the witness had to offer was hearsay evidence, so the judge sided with the prosecution on that. I don't know. I do not know. So last night I pretty much went straight to bed and then got up this morning and I haven't even brushed my hair. No, I still have complete bedhead and complete, like I'm still wearing the same t-shirt. I haven't changed clothes yet today. Lisa said, neither do I. He has been quiet or soft-spoken through the whole trial, no matter what mistakes or disrespect Tucker made. As of yesterday, he had had enough, so his tone has changed, but I don't see it as disrespectful. Judge did tell him he couldn't bring his witnesses in. He wouldn't approve for the guy in jail to come. See, I thought that he said he had had time to do it. And he hadn't went through the motions to get the one that's in jail there. Is what I thought. Because you can't just willy-nilly be like, okay, you know, you have to go through whatever courses of action, I guess, so to speak, to get your those witnesses that are incarcerated in to testify. I am like bleh this morning. But he wouldn't order for transport. He said he had plenty of time to get him there, but had not followed through. Right. Said he'd never received a request. It was something like that. I don't think he could do an order for transport until Tucker had went through the motions to whatever. And then he had also let subpoenas run out, like expire. He could not sign what he did not get. Well, and I do remember the judge saying the transport process doesn't just poof happen. It's a process they have to go through. So, and Tucker didn't do what he needed to do to get stuff done. Looks like the judge is back. I saw the flag move. Well, let's see what happened. Oh, maybe he's not back yet. Maybe it was somebody else. A long process, I believe, is how he put it. Yeah. Don't forget the interview. What interview, Tammy? I watched that interview. You mean the one he did with Court TV? I watched that yesterday. Let's just say that it's a good thing the jury has not been there for all these arguments, right? That would not have been good. Oh, yeah. Yes. Thank you, Tammy. Thank you for the reminder. Thank you. Let me go grab that. Because I forgot that I did say I was going to share the link for it here. Let me grab it. I gotta go back and find it again. Oh. Go to my history because I watched that. So it should be in my YouTube history. La, 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 la. Okay, I think this is it. Yes. Copy link. Okay. Interview with Court TV. There we go. Oh, I didn't mean to show that. Hold on. Okay, I put it in my little notepad section on my computer so that I can copy and paste that link into the chat off and on through this morning, depending on what happens. Lisa, I think there's been mistakes on both sides, and yes, primarily on Tucker's side, but ignorance of the law is no excuse. Having said all that, I still believe he's innocent and just wish he got himself a lawyer. I agree. I mean, people like assist in their own defense all the time, right? Whether it's through administrative things like we saw Hannah Payne doing with her lawyer Tucker, which was crazy. But I don't mean administrative things. I mean like drumming up ideas, thinking outside the box, doing this, help, considering this fact or that fact or whatever. And it's obvious that he's smart enough to do that. This guy is, because he's not done. I think he's done a. I don't even know if decent is. He's done a fairly decent, good job at questioning the witnesses, and even though he's been super repetitive and this and that and the other, but yeah. And he's done way better than I could have ever done. There's no way I could. But I guess whenever, you think you have all those years and the ins and outs of everything inside that story that wraps around what you've been accused of, then you probably would know better what to do or ask or say or whatever. But he should have. All right, they're back.
So we're back. State versus Tucker.
Yes, hello to the lurkers coming in.
17 CFA 41. Court having deliberated upon the latest development in this case, finding that contrary to the court's instruction, that the defense does not have any evidence or witnesses to present this morning, despite the fact that knew that the jurors were coming in, knew that the case was underway, despite the fact of not having any witnesses available yesterday afternoon. So in view of all the developments, the court finds that the defendant's case is complete. And we're going to go to any rebuttal.
Yes, sir.
Then we will excuse the jurors. We will have a charge conference. And tomorrow we will have closings. So
Very well, Judge. Your Honor, would you like me to proffer to the court what my rebuttal case will be?
yes.
Okay, so we've got Officer Daniel Malone here, former Officer Daniel Malone, and we intend on playing some excerpts from her interview with Paula Belmont at the hospital the night of the crime. They're on body worn camera, so I've got the thumb drive here with the excerpts that we intend to play. These excerpts will completely rebut the testimony that the defendant introduced yesterday through Paula Belmont's video deposition testimony. In that video deposition testimony, she talked about how she could tell it wasn't Tyrone Tucker, the second person, et cetera, et cetera. Well, on this video, which was the night of the crime, she completely rebuts that and refutes that with her statements to Danielle Malone. In addition, Judge, Paula Belmont gave a deposition back in May of 2019, and the state also intends to elicit portions or to enter into evidence portions of that deposition, again, that directly contradict or rebut the testimony that she gave yesterday. I've prepared a list of the statements that the state intends on using for the court to review if the court would like. I've also got copies for the defense here too.
Your Honor, I would probably be objecting to hearsay, but, or at least like to know the exception that we're going to use here.
Judge, it's a prior inconsistent statement of the witness, and it's coming in to prove that she made an inconsistent statement, and which is different from the statement she made yesterday in the testimony that the defendant put on. The defendant put the testimony on. It's evidence that he introduced into this trial, and it's the state's right to rebut that evidence with a prior statement made by that witness that is inconsistent, just like with Travis Johnson. Travis Johnson was on the stand, and he was impeached with his prior inconsistent testimony. The defendant put the witness on yesterday. It's evidence that he introduced. The state's rebuttal will be tailored to inconsistent comments or statements made by that witness that rebut what she was trying to testify to yesterday.
As long as it's an inconsistent statement and
Yes,
not something else, then it's an exception to the rule. So
Okay.
Yes, sir.
And Your Honor, since I haven't had a chance to look at what the state's offering, if I remember correctly, did you just say that we are going to be adjourning for the day somewhere's in here? I just want to make sure I heard clear, because then I'd have time to take a look at what they're offering.
Judge, when I handed the court, when I gave the defendant, are the excerpts from the deposition that I intend on eliciting. My plan, Judge, is to simply move them in and then publish them to the jury through reading them, because those are inconsistent statements that would rebut her statements.
Well, and I'd also have to object because you already had your chance to cross Ms. Belmont.
no, the state gets to present a rebuttal case. That's part of the procedure to rebut any evidence that was presented during the defense case, so long as it's genuine rebuttal and not otherwise, like opening up a new
Yes, sir.
avenue. So what I said was that I was going to allow the state to present their rebuttal, that thereafter I was going to excuse the jurors for the day, that we were going to have a charge conference and have closings tomorrow. So I wouldn't expect that we'd be in session all day by any means.
Thank you.
But but this is going to proceed, but if you need a few minutes to review what the state's proposing, and I'm not quite sure, Mr. Mansfield, what your proposed procedure is. I'm not clear. I mean, you gave me this page of excerpts from Paul's first deposition, May 1st, 2019. I'm not sure.
Let me clarify. There's two different pieces of rebuttal evidence I'm going to be moving in today. The first piece of rebuttal evidence, I have the officer here. The officer is going to come in, take the stand, tell us that she went to the hospital to interview the witness, Paula Belmont, that her body worn was on, and that Paula Belmont made statements to her about what had happened the night of the crime.
Okay.
And I have that video to play. That's the first
Wow.
piece of rebuttal. The second piece of rebuttal are excerpts from her deposition that I provided to the court and to the defense. These excerpts are directly on point with various comments that she made yesterday, and these excerpts rebut what she said yesterday in her testimony for the defense.
Okay, so how do you want to publish that? I mean, you're
Well-
not moving this piece of paper into evidence.
Judge, I would seek to move the paper in, or if not, I would just seek to be able to publish to the jury. I'd say, ladies and gentlemen, I'm going to read to you the question and the answer that was provided to
Well,
the witness, and I mean, the question that was provided to the witness and her answer, and I'll just read it to the jury.
and Your Honor, I would like to, again, I would object to that. I would like to, again, at least know which statements you plan on moving the jury, if you plan on moving this whole thing in here.
Okay, so the way it's done, in my experience, is reading the alleged inconsistency that the written transcript or some excerpts from it in writing are not normally the way it's done. Normally it is deposition sworn to on such and such a date, line, page, whatever line, question, answer. The attorneys can either, one attorney can be both the questioner and the witness, or I've seen them, one be the
No, and-
questioner, one be the witness.
Well, Your Honor, if I may
Yes, sir.
take exception again. The state had all of this prior to Ms. Belmont taking her perpetuated testimony. They had their chance to cross her then. They had their chance to rebut that.
I believe that doesn't preclude rebuttal evidence. Now, if you need a few minutes to review this, that's fine.
Judge, and it doesn't preclude. This was evidence. This is why we didn't call Paul Belmont. This is why we let the defense call her.
I understand that. I understand that. You can certainly, present any kind of inconsistent statement if it's in fact inconsistent. So I don't know, Mr. Tucker needs, 30 minutes to review some of this
Yes.
stuff? Or
Yes, that
10
would be-
minutes or 5 or?
I'll tell you, I don't, looking over this, I'm gonna have to take a look at the video and I'm gonna have to take a look at the steps. Are you planning on putting the video into?
The video is going to play for the jury, just like testimony.
Okay.
Well, okay, so, was provided in discovery?
Yes.
Okay, so, I mean, are we having excerpts from the
Yes,
video?
sir.
Okay, so,
On behalf of the client.
for the defense, outside the presence of the jury. So just like, okay, so
Okay.
30 minutes to go through this, and I guess we have all the jurors present. Could you tell them that, we're not going to be with them till about 10:05. They can either stay there or, take a little break if they want to, at 10:05.
And Judge Jones, just for the record, I mean, our apologies. We didn't know there wasn't going to be a defense presentation today. I would have addressed this yesterday afternoon.
I understand.
And one more thing, Your Honor. I mean, again, they did call her when we did the motion to perpetuate. That was your witness.
Understood. Understand, but it was presented in your case. That's the difference. That's like I was explaining yesterday. The deposition is one thing, but who chooses to use it is an entirely different thing. So anyway,
Thank you.
we'll be back at 10:05.
Goodness gracious. So yeah. Good morning, guys. I wasn't ignoring chat. Hey, Joanna. Hi, lovey dovey. Oh, let's see. She says, why do I feel like this case is from the Twilight Zone? Right. I do too. I do too. Lee says, by the way, thank you for having me on last night. It was a blast. Absolutely. Thank you for coming on. It was a blast. We had a great time. If you guys missed last night's case discussion on Scott Peterson, you have to go back and watch because Lee joined us. Morgana was on with us. We missed you, JB's mama. Sending out big prayers for your dad. Joanna said he wore his mowing the lawn shirt to court. Yeah. Lisa, that's his favorite shirt. Apparently, he wears it all the time. Good morning, JB's mama. Tammy says the judge just said he couldn't bring in the paper, but yet he is allowed to read. What's the difference? Oh, I don't know. Back to my J wall. So JB's mama, it's just been a poop show as per usual. I mean, do we expect anything different, right? They got into a really big argument. Yes, you were here for the argument yesterday that they had JB's mama, right? Or did you miss that? They've argued again this morning, first thing. And it's just, they're kind of, judge took a break, said he was going to make a decision, and he came back and he's like, yeah, the defense case is resting. We're not waiting on witnesses. And the state is going to go on with their rebuttal. And Closings will be tomorrow, I think is what he said. Or maybe he said, and then they're going to do their charging conference too, but that's all the legal word mumbo jumbo that is like boring and don't know nothing about it. Good morning, Dawn. Good morning. Good morning. I still say she threw me under the bus. Morgana threw you under the bus. She sure did, right? Ugh. How come no one tells me I feel uninvited? Don't feel uninvited, Joanna. Do you have notifications turned on? And I mentioned it in the live stream yesterday that we were going to go live. I know you don't catch everything, right? It's hard to do that, but yes, ma'am. You're welcome, JB's mama. Okay, you were there for that. Yes. But she did say yesterday she was going to have a live when she closed out yesterday. Yeah. Yeah, we decided to start doing some chatty chats. Like deep dives into we wanted to do deep dives into Delphi, but then we got started on the Pete Scott. I was going to say Pete Scotterson. That's not right. Scott Peterson case because of the whole new evidence, potentially, allegedly. Not so sure about that, but when they fight, it's funny. As stupid as stupid does. I know. Lee says, how is Tony, Dawn? LOL. Tammy says, Joanna, my J-wall is in the closet. I dislike it, so I will have to find it in my heart to finish it. Which one is it, Tammy, that you have? Which J-wall? Joanna said, I have to check. Plus, I'm in and out with the crud. I hope you're feeling better. Lee said, all my cute kitties, LOL. I wish they stayed that way. Kitties never stay kitties, do they? They turn into a full-grown adult cat. But kitties are cute. Oh, gosh. I have the super big yawns this morning. And the super big stretches. Oh, my goodness. Oh, my goodness. JB's mama says Delphi would be a very big on the deep dive, especially with all that has recently come out. Exactly. Nope, these two put Buddha to shame. Belly's almost dragging the ground. I was going to say, are they nice and fat cats? Fat cats are fun. Joanna said, I feel like death warmed up, but thank you for the love. I'm sorry. JB's mama, yes, Delphi. I want to really want to get into that, and I want to get into Idaho 4 and those are the two big ones, right? But then there's also the Daybell stuff. And then I want to, before Lisa Snyder's trial, I really want to introduce that case to you guys because most of you don't know about that one. And I'm really hardcore into that case. So, see, I never got into that one, the Long Island serial killer Rex. I've never got into him, into that story. I mean, I've heard about it and seen about it and all that, but I've not really, I don't know much about that one at all. Tammy said it's from the one with the diamond art. I think that's the name. It's blank. It's black and white. The symbols on the canvas don't match the legend. Glue sucks. It's a nightmare. No sparkle. It's dull looking. Oh no, Tammy. Ew. Oh, Leah's sending all the hearts for Joanna. That's sweet. She needs them. Yes, she does. She needs the hearts and the love and the thoughts and the prayers. Good morning, Morgana. Good morning. Good morning. Good morning. So yeah, there are just so many, right? So many cases. Joanna says, "Oh, you should. They live not far from my sister on Long Island. The crap he got away with. I know. I know it." Mm, I cannot quit yawning, you guys. Oh my gosh, I think I need more coffee. I've been up since 5:30 and I've already had 2 cups, but it's not doing the job. Not doing the job. Lee said, "Hello, notorious one. Stays clear so she cannot throw me under the bus again. LOL." Ah, that's funny. JB's mama said, "By the way, my dad is doing much better today. Me, I'm running on about 2 hours of sleep." Oh, goodness. I'm glad he's doing much better, but you need to rest. Hey, Lee, I wouldn't do that, says Morgana. I don't know where Steph is. I don't know. She might pop in soon, hopefully. Oh, you need at least 2 more coffees. Put the syrup in it today. I don't have much syrup left. We've been going through that. Jenny, how's little Jolie doing? I hope I spelled her name correctly. She's doing great, and you did spell her name right, Tammy. She's doing good. Lee says, "Glad to hear he's doing better. Sorry, however, you did not get sleep." I know. Telling you, caregiving is not for the faint of heart. Not at all. Not at all. Okay, guys, I'm going to take a quick coffee break. I'm going to run before they get started. I think he said they were going to be back at 10:05. I'm going to run and make me another cup of coffee and go to the potty break. So I'm going to have to let the doggo outside too because she needs to go wee wee while it's not pouring the rain. It's been raining all night and morning. and it's warmed up. It's warmed up some, and so all the snow is melted. And I don't have to fight her as much to get her out the door to go use the bathroom, but I have to fight her, son, when it's super rainy out or super snowy out. Morgana, Tucker and the judges already fought. Lee will tell you about it, I'm sure. But I'll be right back, you guys. Oh, Lee says, nope, I'll be right back too. Okay, I'll see you in a second. I'm back. I'm back. I'm back. Let's see if I miss any comments. Are you guys asleep in the chat? No, looks like you guys are chit-chatting. Good morning, sweet Kel. JB's mama said, thank you, Lee. I get a little break today and the nurse is coming. Yay. A lot to write, but they are on break. So Tucker, and review rebuttal case on Paula's testimony. I went back in time to see what happened. Yeah, they totally got a verbal disagreement, didn't they? They did. In a nutshell, an argument over lack of witnesses yesterday and not ready today due to a misunderstanding about allowed versus disallowed witnesses. Let's see. Off the subject, but I want a coupon from Enabler's Outpost, so I have never ordered from them. Where do I go to see the shop? Are they out of the U.S.? Yes, Tammy. That's the place where I get my pins the most. And you just go to enablersoutpost.com is where they're at. Just go to www.enablersoutpost.com. JB's mama says, question, does anyone recognize Tucker from somewhere? I don't. Should we? I did get somebody, I think it was QB Designs. It was QB Designs. She had commented and said that Tucker sounds like Bob Ross. I was like, oh my God, now that you mention it, if you shut your eyes, because, you know, Bob Ross had all the hair, right? And Tucker has none. So if you close your eyes and listen a little bit, yeah, I hear it. Judge did tell him to have what other witnesses he has ready for today. And instead, with the misunderstanding, he told his witnesses not to show. Yes. Yeah, I don't recognize Tucker either. Oh, thanks, Lee, for putting the link in there for Tammy. Thank you, Kel. Looks like an old Gilligan. Oh, wow. Okay, JB's mama. Let me look. Let me look. Yeah, I knew that was her. She's the CrossFit chick. We were talking about that when the trial first started. He was married to her, and she's like an owner or co-owner of CrossFit. Hold on, I'm reading. I'm reading this article. So wait a minute. Was he is he a co-owner too, or just her? Mm, It says here it was in the late 90s when Lauren Janae started CrossFit with her husband to make an impact in the fitness industry, and so they did. Started as a revolutionary training style, what these two gave birth allowed people to get fit and healthy in a competitive and welcoming environment in a way it was never thought of before. So between then and now, Lauren has always managed to stay in the news, be it discussing how she created this beautiful business. Why did I say beautiful? How she created this successful business and community over the last 2 decades. Um, yeah, I don't know. Okay, JB's mama, that comment there about the article. Tammy said he looks so much different from before to now. You guys really should watch the interview Jenny posted. Tucker explained how he knows these people. They also interviewed his wife. Yeah, let me repost that link again. This was an interview that he did on Court TV. It was like a 20-some minute long interview. It was pretty good. It was pretty interesting, to say the least. JB's mama said, I was thinking that he was familiar. So last night when I had a few, I started looking. But I wasn't here when y'all started. I came in on day 3. Oh, okay. Yeah, JB's mama, there's so much out on YouTube about this case. He has a business too. Yeah, I saw that. Something about investments. There was no prenup, so he has rights to that. YouTube page you seen yesterday is his. The free Tyrone Tucker, that is his YouTube page. It wasn't new though. He had started because it said started like 4 years ago or something. So if he's found guilty this week, he has to go to jail, correct? Yeah. Yeah. 100%, and he'll probably get life because he's um, charged with murder. Yeah, that is his. He started in 2019, stated in the article. The investment business, it said of digital currency or whatever. So he's probably like a what do you call that? The digital, I don't even know. I don't know nothing about that stuff. Don't know how any of that stuff works. Yeah, I don't know how any of that works. The whole like Bitcoin and all that kind of stuff. I'm like, I don't know nothing about any of that. Like, I'm seriously like, how does that even work, right? How does that stuff work? Because if it's digital currency, like, how does that turn into actual money? I don't get it. I don't understand it. Like, can I go to Walmart and like pay for my groceries with Bitcoin? How does that work? Somebody in the chat tell me. I don't know how that works. Anyway, so whenever the trial first started, I thought that the Lauren Janae, his wife, which they're separated right now, but or have been, I guess, for a while. I thought that she.
We're back. Anything further before we bring the jury up?
Your Honor, I would actually have to take a little bit longer to review these. I'm reviewing an entire deposition, and the videos that they brought are clips from videos, and I'm trying to get the context of where the clips came from.
Judge, typically on a rebuttal case, it has to be narrowly tailored to.
Okay, first of all, their volume is so low, I can't hear it. I'm going to have to put my headphones back on so I can see if I can hear any better. They're going to have to turn that volume up. Cameraman, turn the volume up. Second of all, he just said he needed more time. So, annoying. Okay. A long and complex subject. Just saying that will probably be longer to explain than to give a Reader's Digest version on this case. Oh, the whole Bitcoin thing? Yeah, I don't know. My nephew tried to explain it to me one time, and I was like, yeah, no, I don't get it. I'm not getting it. I don't understand this. You speak English to me. Yeah. All right. I'm going to put my headphones in and restart this, see if we can figure out what they're saying.
The issues that you're rebutting. So I took clips from the interview with Paula Belmonte at the hospital. The clips, I think, total like a minute and 20 some seconds. The defendant, I guess,
I'm just
wants
reviewing.
to watch the entire video. I have no objection to using the entire video. Whatever way he wants to go, but that's where we're at, I think.
Your Honor, for me to know that, I just have to review it, that's all.
Review what?
I'm just reviewing I was actually reviewing the video right before you came out, Your Honor. I'm trying to make good use of my time. There's actually 3 videos, and I'm not even sure which one it is.
There are excerpts from the 3 videos where she talks about her inability to ID the second assailant. That's what they are.
And,
How much more time would you need?
I don't know, Your Honor. Again, I'm not going to need that much time. I mean, as far as, reviewing the videos, but then I also have to review the depot where these are coming from, because he didn't provide the entire depot. At least not that I can see here. Again, it's being excerpts from the depot, and I don't know the context.
How much time would you like to have?
To do the entire depot and check the videos, all 3 of them, I'd say at least a half hour, Your Honor.
How long would you anticipate this presentation to be?
Judge, maybe half an hour total?
I'm just contemplating bringing the jurors out, telling them to come back at 1 o'clock, letting this unfold, because I just don't want to continue to go back and forth and have these people waiting further. So
We agree, Judge.
if that would make it more palatable or convenient. I mean, none of it's convenient for the jury, but if that would be more considerate, then we could resolve whatever objections there are to this. I could tell them to come back at 1. We'd be prepared to present to them. Then we can have our charge conference. I'm assuming, I inquired a few days ago about proposed jury instructions. I'm assuming that package is together.
It's in the process, Judge. I'm just about 90% done, but I'll have them by this afternoon. And I'll email Mr. Tucker his proposed jury instructions.
And jury verdict form.
Yes, sir.
That was my question, Your Honor. So they already addressed.
And so then if we let these folks go to 1 o'clock, we have them come back, we have the rebuttal case, we do our charge conference. I guess that's the best way to handle it. That's way I don't have to continue to come back and ask how much more time. And wait a second, just hold on a second. All right. Have a seat, folks.
All jurors present in the court,
Ladies, gentlemen, good morning. Good to see you all here. So I can assure you, I can tell time. I know that clock says 10:15, and I know I told you to be here at 9:15. So I, in good faith, believed that we'd be able to get to you at 9:15, but just like all of you and all of humanity, I can't predict the future. I do my best to try to gauge how much time things are going to take and what's going to happen. Sometimes I'm accurate and sometimes that's not as accurate. Unfortunately, in this particular case, I haven't been as accurate as I think I normally am. So I have to, again, be very grateful for your patience, your understanding, your attendance, and all the other things that it takes to be a juror on this case. I do want to advise you that we haven't been idle here. In other words, while you're waiting, it's not like we're all taking an extended coffee break or none of the above. We're working and making progress in terms of ultimately getting the case to you. And so I can advise you that the defense presentation has been completed, that I can advise you of. And so the next step is the state's going to have an opportunity to present its case in rebuttal, which will be relatively short. And so what we need to do, or what has to happen now, in light of the fact that we've reached this juncture in the case, once again, I have to spend some time with the attorneys outside of your presence. How long is that going to take? I don't exactly know, but I do know that the best way to do it and try not to keep you in limbo is to excuse you to 1 o'clock. And that way I am as confident as I can be of anything that at 1 o'clock you'll have evidence and rebuttal presented to you, and the evidentiary portion of the trial will be over at that time. What that then means is that the lawyers, defendant, myself, will confer outside your presence. You'll be excused, and tomorrow we should be able to go to closings and deliberations. So again, I always try to be mindful of your scheduling, your time, try to give you the best feedback I can as to where we're at in this process. So again, I apologize for the wait, but this is where we're at, and I'll look forward to seeing you back at 1 o'clock, and have a good rest of the morning.
Lord, Lord, Lord. This is embarrassing. I mean, if I was the judge, I would be embarrassed.
So we're going to 1, so so you think that, Mr. Tucker, so
That's more than enough time.
well, no, I mean, I've got to come back here. I don't have to, but I would think I'd need to come back here at 11 to see if there's any objections. I mean, so if you have any objections, I want to be able to rule on them so we don't find ourselves sending these folks back and forth again.
So 45 minutes, Your Honor, is that what?
That's what I'm estimating. I mean,
Okay, no, I'm just checking.
so like 11:05, and sometimes the opposing sides actually reach agreements on some of this stuff, where one side may say, gee whiz, I have a problem with that. Did you notice that? And the other side might say, oh, okay, we'll withdraw that one. Other times they don't. They need the judge to make a decision. So if there's any agreements and if there are any objections, if they're not, that's whatever. I'll be back at 11:05.
Thank you.
Gee. Lee says, well, if it was to be put into evidence, they had to give him a copy. In the case of not allowing it, into evidence, he still had a right to review what they are going to bring up. Yeah, I agree. I agree. Oh, I just got diamonds all over my elbow because I'm leaning over into my drill tray. Anyway, hold on a minute. All right, so they're going to be back at 11:05. I'm going to go look at I'm going to go look at something else. Mm. Hold on a second. There was some stuff I was going to share with you guys when we got a minute. I just have to find it. Mhm. There is that trial that I had mentioned the other day that I wanted to start, the pizza delivery murder retrial. They had opening statements um, yesterday, and I was going to see if they actually streamed the whole thing or not. Because I just saw just like clips of the opening statement. So, um, let me go look and see if I can find it for you guys. Because the opening statements always kind of gives you the storyline, of what is going on. Her name, the defendant, is Erica Stefanko. Day one. Let me look. Okay. I think this is it. Let me pause it and then rewind it back to the beginning. And And then let me get back over here to you real quick, see if I've missed it. Tammy says, wasn't the Malone person a witness before during this time? The one that testified she got fired? Yes, that was Malone. Danielle Malone, I think. She was the yeah, she was. She was the investigator that he kept asking her about her mishandling evidence, and she got like demoted or something. And she said she didn't want to work as a cop anymore, so now she works as a 911 dispatcher or something. That's Malone. Yeah, that's her. Okay, so this case here is let me share this tab, and then I'm going to make it big.
Ladies and gentlemen of the jury, we are here to
Oh, sorry.
hold this
Gotta
defendant.
Pause. Stop talking, lady. Lady, stop talking. Sorry if I just busted your all eardrums. I did not. I mean, we go from super quiet over there on this treehouse murder trial, and then we come over here to this one, and she's like screaming at the top of her lungs, I feel like. But yeah, this is the opening statements for this trial. The Erica Stefanko, it's Ohio v. Erica Stefanko. This chick is the one who, let me hop on here real quick with you guys. So this is the case. This is a retrial because she was found guilty in the first trial, but there was some sort of they won their chance for a retrial. So that's what this is. And the reason that they got the retrial is because something to do with COVID. There was some testimony that they did over Zoom with a mask on, and apparently that was something or other. I don't know, but and because of that, they said yeah, she could have a retrial. So that's what they're doing, and this Erica Stefanko is charged with. I don't remember if she's charged with. I mean, I don't know if it's actual like murder charges or if it's like conspiracy to commit or whatever. I'm not positive, but um, she was with a guy named Chad Cobbs, I think, and Chad murdered his ex-wife. I don't know if they were married or not, but her name was Ashley Biggs, and she worked for a pizza place like Domino's or Papa John's or something like that. And the girlfriend, which is the Erica Stefanko, had called to order a pizza and used like a different name or whatever. And so she knew Erica was going to be the delivery driver, or maybe they requested her or something. I don't know. But she delivered the pizza, and when she delivered it, it was delivered to like a business address or something. And the like instructions said to bring it to the back door of that business address. And whenever she did that, and it was late at night, whenever she did that, her husband jumped her, killed her, or the ex-husband or the ex, they had kids together. So he kills her, and she helps the Erica Stefanko like clean up and all that. And so, and the Chad guy is in jail. Um, and now Erica is being retried because of the um, COVID whatever that caused a retrial. So, yeah, I know another Chad, right? So that's what this one is. And this is the, we'll do the opening statement. So, it when it started a minute ago, automatically it was very loud. So maybe turn your volume down on your headphones or AirPods or whatever. And Steph says, "Dang it, I slept through my alarm again." No worries. I'm glad you're here. You're here. That's all that matters, Steph. We're getting ready to watch some opening statements for another trial that is starting or going on or whatever. But we're waiting, Steph, for Tucker has requested time, and they're supposed to resume back at the treehouse murder thingy at 11:05. And go from there. But apparently the jury won't be back until 1 because the judge is done with Tucker. And yeah, that was a whole big poop show this morning. This one is that we're going to show. I'm just going to show the opening statements. I'm just trying to fill up time till the judge comes back. But this is the pizza delivery murder retrial. If you rewind back like 5 minutes, maybe, if even, I kind of went through the story of what happened. But the chick on trial, her name is Erica Stefanko, and she basically helped her dude kill his ex baby mama. And yeah, yeah. Hey, Henny. Hi, Henny. Hello, hello. Good morning to you. So anyway, yeah, turn your volume down because this chick here on the screen is loud. So get ready. All right, I'm gonna mute myself.
Erica Stefanko. Ladies and gentlemen of the jury, we are here to hold this defendant, Erica Stefanko, responsible for what she chose to do on June 21st, June 20th to June 21st of 2012. We are here to hold her accountable for the actions she chose to take. Ladies and gentlemen, in the words of Shakespeare, a rose by any other name is still the same. That means whether you hold the defendant responsible as the principal actor or as an accomplice, all paths, all roads, all lead to the same thing, that the defendant is guilty of aggravated murder and murder. Evidence and testimony will show that this murder could not have occurred without Erica Stefanko. Chad Cobb and Erica Stefanko planned it together and they carried it out together. Now, as you listen to the evidence and testimony in this case, the state would ask that you keep the concept of complicity in the forefront. We would ask that you keep in mind that a person who knowingly aids, helps, assists, encourages, directs, or associates himself or herself with another, either for the purpose or in the commission of a crime, is regarded as if she were the principal offender and is just as guilty. And is just as guilty as if she personally performed every act constituting the offense. The state would like that you keep in mind that as you listen to the testimony and evidence, that when two or more persons having a common purpose to commit a crime, and one does one part and the second does another, those acting together are equally guilty. The state would ask that you keep in mind as you listen to the testimony and evidence that a person who is complicit with another in the commission of a criminal offense is regarded as guilty as if she personally performed every act constituting the offense, even if she did not perform every act, even if she was not present at the time the offense was committed. Now, my co-counsel talked to you a little bit about that during jury selection and the example he gave about the mob boss in New York calling a hit in California, or the getaway driver in the car waiting for the individual in the bank robbing it. Okay, do you all remember that? Now, I said we're here to hold her responsible for her actions. What happened? Who all was involved? Well, what happened is Ashley Biggs was murdered. She was lured to her location. She was tased, beaten, zip tied and strangled to her death, thrown in the back of her car, driven to an entirely different county, and dumped in a cornfield. That's what happened. Who all was involved? Ashley Biggs. She was 25 years old at the time, and she worked at Domino's Pizza. Ashley Biggs had a child, Grace Cobb, approximately 7 years old. She had just gotten temporary custody of. She was in a relationship with an individual named Brittany Dunson. They were with Grace Cobb at that time. And I stated she had just got temporary custody. That would have been from the father, Chad Cobb. Chad Cobb is currently in prison serving life without parole for the murder of Ashley Biggs. At that time, Chad Cobb was married to the defendant, at that time, Erica Cobb. So you have one couple on one side, Brittany Dunson and Ashley Biggs, and you have another couple on the other side, Chad Cobb and Erica, now known as Erica Stefanko, and you have a child in the middle, Grace Cobb. So, how did this come about? Well, on June 20th to June 21st, the defendant, Erica Stefanko, made a call to Domino's Pizza. That call lured Ashley Biggs to her death. And it wasn't just a phone call. That phone call came in at approximately 11:42 at night to a business that was closed, and not just to that business, but to the back door. That is what was specified, have the driver go to the back door of that business. And she used a fake name. Evidence and testimony will show once Ashley got to that business, and you saw that on the jury view, she was ambushed. She was ambushed. That's where she was tased. At that location is where she was beaten. And that is the location where that zip tie was placed around her neck, causing strangulation and her death. Evidence and testimony will show that Ashley Biggs did not leave that parking lot alive. Evidence and testimony will also show that the defendant had conversations. The defendant was under a tree Evidence and testimony will show the prior calculation and design, what went into this crime. Evidence and testimony will show that the defendant laid in wait while this was happening to Ashley. Once Chad put her in the back of that car and drove away, the defendant followed him from that location that you were taken to on the jury view on West Turkeyfoot Lake Road to an entirely different county, to a cornfield. Once there, evidence and testimony will show that Chad drove Ashley Biggs' car. Can't drive two cars. Evidence and testimony will show that Chad was driving Ashley's car and the defendant was in tow, following right behind. He drove that car to the far corner of that cornfield, the far right corner, while the defendant waited. Evidence and testimony will show that when Chad Cobb came back, he was bloody. He was dirty. He just got done walking in the cornfield, and it was visible for all to see. And evidence and testimony will show that it was the defendant that drove him home to shower away the evidence. But thinking, if you look like this, Chad, what does the scene look like? So it was decided to go back to the scene and try to clean it up. And evidence and testimony will show that the defendant, Chad, I failed to mention 4 children who were in tow. And I mean in tow from the beginning, from when the defendant made the call to lure Ashley to the building, from when she stayed and laid in wait in the car until it was over, when she drove a whole county over following Chad to the cornfield, when she went home for him to shower. And now these children in this car is coming back out to the crime scene for them to try to clean up the mess. And keep in mind of these times.
Yes,
However,
Gail.
evidence and testimony will show that it did not go as planned when they got back to the crime scene, for the police was already there. And what did they do? Together, they went and hid behind that detached garage at 731 Rex Lake Road. And this is approximately 4 o'clock in the morning with 4 kids in tow. That's what the evidence.
Tammy, this case just started I think yesterday. Yeah, I think these are opening statements from yesterday. And it did start. It was supposed to have started last week, but they had to delay it because one of the prosecution or one of the defense, one of the lawyers was sick with COVID. So they had to delay it like another week or something. Steph says, "Don't yell at me yet. I'm in the bathroom." Hi, Steph. Let's see. So yeah, anyway, this one was one that I did want to start originally the day that Steph decided to go with the treehouse murder. This was the other one that I wanted to start. This isn't the same one of the big house that we watched. That was the Michelle Troconis, a different story. But this one is a retrial. She's already been charged, she was already found guilty once. Right, it hadn't started yet, Steph. Right. It was supposed to have, and I kept waiting for it and watching, but then it never did. And then come to find out it was because one of the lawyers was sick and they had to delay. So this one started yesterday. Opening statements did. But like I said, she was already found guilty once. But because one of the witnesses, which I think is the Chad guy, the one that actually committed the murder of Ashley Biggs, had testified via Zoom with a mask on, and apparently that wasn't supposed to have happened or something. So, because of a technicality, um, um, now they're retrying her case. So, anyway, I'll restart this. But yeah, there were 4 kids that were in the car through the whole thing. So, crazy pants.
Will show that they were together through this whole thing, the planning, the execution, the cover up. Now, evidence and testimony will show, and you will hear from different witnesses and see different things. I would like to talk about 2. You will hear from a Cindy Cobb. Evidence and testimony will show that Cindy Cobb secretly taped a conversation between her and the defendant. Evidence and testimony will show that this is a free-flowing conversation. Defendant is talking freely. And during that conversation, evidence and testimony will show that defendant made several admissions. Admissions that prove prior calculation and design. Admissions that go to complicity. Evidence and testimony will show that during that conversation, the defendant said he came up with how to do it. He executed almost all of it. The part that he executed went totally awry. Evidence and testimony will show that the defendant is talking about Chad Cobb. The defendant admitted, because I remember the conversation that we had under the tree, because we really were literally under a tree when we had the conversation. And he's like, you know, if I do this, there's no turning back. Evidence and testimony will show that tree, that location was at 647 Rex Lake Road, the scene of the murder. The defendant stated in that conversation, he would get this look on his face and be like, yeah, if this goes through and I can do this, I'm going to keep her skull as a trophy. During that conversation, evidence and testimony will show that Cindy
cracked me
Cobb
up,
said, at one time,
You
you
cracked
told
up.
me face to face that you made the phone call and you set the meeting up. I mean, that's what you had told me. Evidence and testimony will show the defendant's response, and there's no lie in that. She states, and there is no lie in that. But like I say, if Chad said, this is what we're going to do, and this is your part in it, and I carry out my part in it, I did exactly what he told me to do. It wasn't because he was forcing me to do it or like he had a gun to my head. She said it wasn't like he was forcing me to do it or like he had a gun to my head. It was because he says, this is your part and this is what you're going to do, which is how it always was. Evidence and testimony will show that goes to complicity, that she was part and parcel. The defendant stated, if what was supposed to happen that night happened, he had the perfect plan. But it didn't go the way it was supposed to go at all. And why that is, I don't know. Because he told it to me 2 different ways. It doesn't matter now. That goes to show again, prior calculation and design. Evidence and testimony will show that the defendant stated, and this is again to Chad Cobb, you know what you can do and what you can't. If this is something that you can't do, then I'm okay with it. And I agree with it. If you can't do it, then obviously you shouldn't do it. And she goes on to state, I always threw the ball back in his court. I don't think those are the exact words that I used that night because we had already been over it so many times. Evidence and testimony will show that night meant the night of the murder. She said, I'm like, this is the only way the situation is going to go away. I feel like he felt pressured by me to do something about it. I should have at that point said, this is too risky. Because I just see him get away with so much shit that I thought he could get away with anything. Evidence and testimony will show in that conversation. If everything, the defendant said, if everything had been told exactly as it happened, and if everything had been told exactly as it happened, then we'd both be in prison right now. Then we would both be in prison right now. I don't disagree with that. That is totally the truth. These are Erica Stefanko's words. Cindy says, I mean, do I think it took two of you to get where you are today? Yeah. And the defendant replies, I'm not disagreeing with that, but it took two of us. He's trying to put it all on me. I have a problem with that. Again, whether you hold her accountable as the accomplice or as the principal, all roads lead to the defendant being guilty of aggravated murder and murder. She says, you know, you can't like really function in everyday life if you're gonna look over your shoulder every second. Every time I hear a siren, I think they're coming for me. And that's something I'm gonna live with, but I don't need him contributing to it. The way he went about it, unless his real intention is to actually throw me in prison, I'm gonna need to make arrangements to see what's gonna happen to the kids. These are the defendant's statements, ladies and gentlemen, in a secretly recorded conversation where she is freely talking. Now, because of the rules of evidence, we may have to play that conversation. It's a little under 3 hours long. You may not be able to hear it. I just ask that you be patient with the state because of the rules of evidence. But when it's time to go back and deliberate, please take the time to listen to that tape. That's not the only time you will hear about statements the defendant made. There's another witness by the name of Mary Brinkman. Mary Brinkman is her kid's godparents, an individual that she trusts enough to be godparents. Mary Brinkman will testify, evidence and testimony will show the defendant admitted to dropping Chad off at that location. She admitted to following Chad, and she admitted to hiding out behind a detached garage. Ladies and gentlemen, evidence and testimony will also show there is no DNA evidence connecting this defendant to the scene. And the state would ask again, you keep in mind the concept of complicity and the mob boss who orders a hit in California, or the getaway driver who sits in the car while the person is in the bank. Once you listen to the evidence and testimony in this case, the state is positive, confident that you will find the defendant, Erica Stefanko, guilty of murder and aggravated murder, for it was the defendant who was part and parcel of the planning and execution of this murder against Ashley Biggs. It was the defendant who made that call and lured Ashley to her death. It was the defendant who laid in wait until Chad got in that car and was driving Ashley Biggs' body. It was the defendant that followed him to the cornfield and again waited for him to drive the car way to the right side and come back. It was the defendant who drove Chad home to clean up that dirt and blood that was on him. And it was the defendant, Erica Stefanko, who drove back to the crime scene. And it was the defendant who was found hiding with him behind that detached garage that night. And all of this with 4 children in the car, ages 7 to under 1. She was in it for a penny, in it for a pound. With that, ladies and gentlemen, the state would ask that you find the defendant guilty beyond a reasonable doubt of aggravated murder and murder. And thank you for your time and patience with this case.
I feel like it's been a while since we've seen each other, so I'll reintroduce myself. I'm Jeff Laybourne, along with Angie Killey and Mike Kranek here, we represent Erica. We really appreciate your patience in this, and generally, I know I can speak for all parties. We really appreciate your service. This is very important to the system, and obviously very important to Erica. Now, before I get into it, I just want to comment about something that the prosecutor, closed up with. In for a penny, in for a pound. In for a penny, in for a pound. I haven't heard that phrase in a long time, but I think what you're trying to say is, look, if you're involved a little bit, you're involved all the way. And I understand why she used that euphemism there. Because what you'll hear through the testimony and the evidence is that they've got about a penny's worth of evidence here against Erica Stefanko. What you will hear an overwhelming amount of evidence about is what Chad Cobb did. That he alone had the intent and purpose to do this. That he set it up alone. You'll hear evidence and testimony that he had a volatile relationship with Ashley Biggs, involving protection orders and things like that. What you'll hear is, based on all of that, is that he had the motive to do this, not Erica. You'll hear that that night, Chad Cobb was dressed head to toe in full camouflage. You'll hear that he was alone behind that building on West Turkey Foot Lake Road. You'll hear that he alone killed Ashley Biggs. You'll hear testimony that he used an assortment of tools and weapons that belonged to him, that were his property. You'll hear that he alone drove Ashley Biggs to that cornfield. You'll hear that that place was not just a random place that he picked. The place that he picked to drive her car and her body was a place that was special to he and Ashley Biggs. You'll hear that that place was their bridge. Not he and Erica, he and Ashley. You'll hear that this place also is not random, in that it is very, very close to Chad Cobb's parents' home. You'll hear that he alone, not Erica, called his parents right after he committed the offense, including his mother, Cindy Cobb. We'll hear a lot about her. You'll hear that he alone needed clean clothes afterwards. You'll hear that he alone was hiding in those woods behind his grandmother's house. Not Erica, Chet. The property that he chose to hide at in those woods was his grandmother's house. You'll hear that his DNA and his DNA alone is at the crime scene. You'll hear that he purchased phone cards at Walmart. You'll hear that he and he alone was indicted for the murder of Ashley Biggs. You'll hear that he was facing aggravated murder, kidnapping, tampering with evidence, retaliation charges. And importantly, you'll hear that he and he alone was facing the death penalty. You'll hear that he accepted responsibility. That prosecutor right there dropped the death penalty. Chad Cobb pled to the charges in the indictment. He pled an agreement for them to drop the death penalty specification and that he would serve a sentence of life without parole. And at this point, you'll hear, once he gets to the prison, once he starts serving that life sentence, you'll hear that things started to change. What the government did not tell you in their opening statement is that while he did accept responsibility, shortly thereafter, he filed an appeal to withdraw his plea. You'll hear that that appeal was denied. You'll hear that that did not stop Chad Cobb. Because you're going to hear that Chad Cobb believes he's getting out of prison. And that belief is important to this case. You'll hear about his belief that he's getting out of prison. Importantly, you'll hear about his mother, Cindy Cobb, her belief that he's getting out of prison. She believes it. You'll hear about his daughter, Grace Cobb, believes he's getting out of prison. And as a result, the Cobbs have not stopped fighting for Chad. You're going to hear that they've undertaken additional appeals. You're going to hear that Chad Cobb has an attorney now to help him change his story. You're going to hear a lot about Chad Cobb and Cindy Cobb and Grace Cobb and about belief. What you're also going to hear is you're going to hear the prosecutor's elicit testimony that is going to be an attempt to make Erica look bad. And you're going to hear that they're going to try to use this looking bad testimony to try to stretch to an aggravated murder conviction. It's the penny and it's the pound. They've only got a penny, so they've got to throw that in there. They're going to use Grace Cobb to try to make her look bad, and therefore she's then guilty of aggravated murder. They're going to use Cindy Cobb, who tapes her secretly and doesn't turn this tape over for years and years until that belief started to bubble up. Chad's getting out. It's time to act. We've got to put this plan in motion and pin it on Erica. You're going to hear that pinning it on Erica solves a lot of problems for Chad Cobb and Cindy Cobb. They're going to use some allusions to, either directly or indirectly, that she had an affair with Chad Cobb's best friend, Mike Stefanko. That makes her guilty of murder. It's a penny. You're going to hear from Mike Stefanko, Erica's husband. They're married to this day. I ask that you not be fooled. So as I said, this case is about belief. You're going to hear testimony about belief. The belief of Chad Cobb and the belief of Cindy Cobb. And the belief that if they implicate Erica, it gets her out of the way. You're going to hear it's going to help get Chad out and get Erica in. That way, Cindy Cobb doesn't have to deal with Erica, with the grandkids, custody, visitation, weekends. Cindy Cobb doesn't want to deal with any of that. They need her gone. Now, the state can talk about penny and a pound, but the judge is going to give you the instructions on complicity. And that's what she's getting at with the penny and the pound, but it's not that simple. You're going to hear that the government has to prove beyond a reasonable doubt that she had the same criminal intent as Chad Cobb. So they've got to prove beyond a reasonable doubt that she had the same intent as Chad Cobb, that she shared the same purpose as Chad Cobb, that she shared the same state of mind as Chad Cobb. You're going to hear from Chad Cobb. And I want you to think about his state of mind and who could share it other than Chad Cobb. You're going to hear about co-defendant or co-conspirator testimony. And the judge is going to tell you to view that testimony with, quote, grave suspicion. That's Chad Cobb. You'll hear that Chad Cobb brought Erica and Cindy in on this thing after the fact. Chad Cobb.
So, and then presumably has had an opportunity to view the rebuttal material or.
We're back over here, guys, for a second.
objections.
Your Honor, there's a couple of things I'd like to go over with Mr. Mansfield, I guess, on this. The videos, he stipulated that he would play them in their entirety. I agree. You know, if we're going to play the videos, we play them in their entirety.
Judge, let me explain. The three, typically speaking, what I'm using the videos for is to rebut her statements about IDing the second person that came in yesterday. So I pulled 3 snippets from the first video at the hospital, 3 clips from the first video at the hospital. Mr. Tucker wants that video played in its entirety, so I will play the first video in its entirety where these 3 clips were pulled from. Then the interview goes on, they go outside of the hospital. I'm not playing all that. That's not my purpose in using this video. My purpose is very specific. I'm rebutting the statement.
Ooh, that was loud, whatever that was. Quit touching that, Tucker. Oh my God.
What she knows about the second person in the treehouse that night versus what she's saying here the night that it happened.
Your Honor, if I may. Well, first off, you know, I would like to renew my objection to the videos coming in at all because, you know, again, the perpetuated testimony was supposed to be used solely if she was unavailable and nothing else after that. They had all this available to them at the time. They got their cross in, all that at the time, and now they want to go ahead and redo it. Since mine was stricken from the record, I would suggest that, you know, that yes, I'm not going to get an opportunity to redo mine. I would imagine they don't get to redo theirs.
I'm sorry, when you say
Her original
mine?
testimony when she came in to testify, Your Honor, it was stricken from the record. So I didn't get to actually cross her. I didn't get to actually direct her, I should say. But now they would like to go ahead and recross, even though they've crossed this testimony before.
Yeah. Okay, well, I'm going to overrule the objection because I don't believe it's a recross. In fact, it's a rebuttal. So
Okay.
I believe they're entitled to present rebuttal, and I believe the Zoom effort with Ms. Belmont, I covered that completely, and I don't think that's pertinent at this point.
Your Honor, I just wanted it on the record. That was all.
Yes, sir.
Now, as far as the current videos, Mr. Mansfield was not able to tell me which videos they were pulled from, so I had to go and look at all 3. I didn't do so completely, but I kind of have an idea, I guess, which videos he's pulling from. And like I said, any video he's pulling from, I'd like it played in its entirety, just for context. Because taking clips out of context, taking sound bites out, I don't like that idea. It has a danger of prejudicial impact on the jury.
So, Attorney,
Again, I have no problem playing the video that incorporates all 3 of these statements. But once the last one is made, I'm not moving anything in beyond that last statement about ID. So to play that that's not what I'm planning on presenting.
okay, just so I'm clear. Just let me understand the issue here. The state has, when we say a video, could you again identify what, where, when?
Yes, sir. It's a video at the hospital the night of the event when Miss Belmont was taken to the hospital, and Danielle Malone approaches her in the hospital and begins to ask her questions about what happened at the treehouse. And Miss Belmont gets into detail about the assailant, and both assailants actually.
Okay, so there's portions of that you believe rebut assertions, statements in yesterday's deposition to perpetuate.
Correct, Judge. That's
And Mr. Tucker would like to have context, so you're amenable to that interview in the hospital being played.
The portion of the interview that addresses the ID of the second assailant. Then that interview goes on, but that's not rebutting anything at that point. My rebuttal is her statements about that second assailant. So I have no problem playing the video that incorporates the discussion about the second assailant. But at that point, I don't think there's any purpose in playing the rest of her interview because I'm not using that to rebut anything.
So is there anything further from the defense about this issue?
Yes, sir, because innately, I guess, what Mr. Mansfield's trying to argue is that, we're not going to use these cuts, but we're going to go ahead and cut it right then and there. And, again, you're removing all context of where, what was happening, what was going on, her state of mind at the time. You're really, again, if you're going to use this as a rebuttal, you have to provide the complete picture.
There is a rule of completeness, but that doesn't go to the entirety of the interview.
No,
If there was some statement that she made and they chopped it off in the middle of the sentence or within a paragraph that explained, that would be one thing, but there's no obligation to play the entirety of the interview.
Well, it's not that long, Your Honor. And to be quite frank, I'm looking through the deposition here, and that's exactly what they did. They chopped out different sentences.
Well, as long as those sentences are not misleading or they're, but.
That's why we haven't gotten to that part yet, Your Honor. But I'm saying is the video is not that long. If it's the first one, if that's what he wants to use, I don't see why we don't just play it in its entirety.
I've already said I'll play that one in its entirety, the first video.
Okay, and that's the only one. That's the only one with the cuts, right?
So we
Okay,
both know what
we're
we're
in agreement.
talking about. The first video.
Yeah, we're in agreement.
Okay, so, all right, fine. So what other objections are there?
Well, at this point, again, I've been going through the deposition, and I'm almost inclined to want to go through literally just submit the entire deposition. Because, again, these sentences are cut out. They're cut out from, again, they're taken way out of context. And if we want to provide the jury a clear picture of what she said, I think we give them the entire deposition.
But that's not the goal.
He's almost doing it already, Your Honor. He just takes out the stuff he doesn't like.
Well, again, if it's misleading, if it's not complete, but
That
the
would be the case.
state is not under an obligation, or vice versa, either party is not under an obligation to present adverse material to their case, especially if it's just redundant as to what the other side already presented.
Well-
So if there's some particular excerpt that's objectionable, I'll be happy to look at the
Your Honor, like I said, I haven't had a chance to go through the
Yeah.
entire thing, right? But as I've seen so far, right, literally, we would have to go through, and again, we're going to have to go through piece by piece by piece. And yes, there's different parts where, yes, it is definitely misleading.
Well,
You know,
okay,
so-
well, let's get started because I'm
Oh, and the other thing, Your Honor, I did have one more issue, or not issue, but one thing I'd like to address is, okay, if they want to go ahead and play this video as a rebuttal, we have videos that actually add context to this video that we would like to play.
okay, so,
The defense doesn't put on a rebuttal to the state. I'm rebutting evidence he introduced yesterday with that video at the hospital and the deposition. We've already covered the video from the hospital. I would submit we need to start going through the different deposition statements and see if the court will make a ruling as to whether we should be able to go into those or not.
In all honesty, Your Honor, this should have been addressed before we came in today. I would say, it's not like I haven't been, available for communication. I haven't been available to go ahead and to go ahead and look at these things. But what I'm saying is, okay, again, she says things in this deposition specifically in response to things that, happened outside of the deposition. And again, it takes it out of context.
okay, well, again, let's look at the specifics because that's how we handle it.
I would agree. That's fine, Your Honor.
Okay, so this deposition was a discovery deposition?
Yes, sir. Back on May 1st of 2019.
Do you happen to have a copy I could look at? Or
Judge, I gave you the excerpts.
you gave me the excerpts, yeah?
You want the entire deposition?
I can
Well,
actually.
I have it.
Well, thank you. Okay, so
Judge, first and foremost, let me draw your attention to the beginning. The witness was sworn in, so we covered that. The first excerpt the state intends to potentially use is on page 13. It's a rather involved question and answer about identity. Yeah, and dark clothing, I don't remember. It's been a year.
wait.
Hold on. Could you please just give me a second to pull it up so that I can follow, please?
Page 13, line 1, just reading from the, actually, from what I can see, it's lines, you want to use lines 1 through 25.
Yes, sir.
Okay, so go ahead, read it.
And the first one. is just-
Actually, I can read it. I don't need you to.
Fair enough.
Well, let me read it. Is there an objection to this excerpt?
Well, just 1 second. I just got it up there. So, let's see what this is here.
Yeah, he is Lee for sure. Can you blame him though? Holy cow. Right, Tammy. I feel the same way. I mean, it would have, I think it would have just been a much smoother process. And the jury wouldn't be yanked back and forth. Like,
This is what
I don't even know. I mean,
I don't have
seriously.
anything necessarily in opposition to in this section, Your Honor, but she does go into later. She actually
Dawn.
says some things that add to this section.
Okay. Frank, if you have no objection, that's fine. I honestly, starting at the top of the page, it's like confusing. I don't know who it's talking about, and moreover, it doesn't seem to be inconsistent. She's talking about Rory Wilson, at least on. So what?
Judge, may I jump in?
Yeah, go ahead.
So, I included the beginning of the page just for context, but she really gets down to it. Line 10. Are you sure it was Rory Wilson? Absolutely, without a doubt. Who else did you see there that night? No one that I can identify. Do you know Ty Tucker? I know him, yes. Did you not see Ty? Not that I can identify. I saw another person, but I can't identify him. In the perpetuated testimony yesterday, she was adamant 100% when Colorado asked her that it wasn't Ty Tucker. Here she's saying she can't identify the second person.
Understand that.
I don't think it was buffering on my end,
Inconsistent
Lee.
With the testimony, I just didn't, again, understand how.
Anybody
the portion
else?
About Rory Wilson, but again, if it's given
Yeah.
context.
Your Honor, could I again interject here? I don't mean to, I don't
Yeah,
want to
yes,
step
sure,
on your
go ahead.
toes, but okay, but this is what I meant by the videos again. Because, okay, it is inconsistent with a statement she made, but she also says in her videotape deposition, that was the perpetuated testimony. She says there was a time there, the detective Pitcher had her thinking it wasn't me. And unfortunately, this is the result of that time, which we have the videos of where he is confusing her. He is giving her other information. He's feeding her information saying it wasn't me. That is, again, not inconsistent with what she says in her perpetuated testimony. She says exactly that.
Well, I'm going to overrule the objection. I mean, if,
I just think it would prejudice the jury to think that, man, she's actually saying something. Again, she is in different states of mind depending on when these were asked.
right, this happened immediately after the
No.
episode.
Not the deposition.
Oh, not the deposition, you're right. But in any event, I think that, that's,
I think in all fairness, we should show the context. I mean, again, she says that Detective Pitcher had her questioning at a given point. And I can see why when you look at the videos.
in any event, I'm going to allow this particular excerpt.
Okay.
So then we go to the next page.
Page 14.
This is just a continuation.
It is a continuation, Judge.
Let's see. Let's see.
Okay. Is there any objection to this segment?
Yes, Your Honor, because again, this one actually does have sentences that are removed. They have, again, there's things in here that are removed. I'd have to again go over it quickly here just to make sure that.
Sentences that were removed.
Yes, there's statements that are actually removed from this. I mean, if our copies are correct, it's
Page 14,
Yep.
lines 1 through 25. What's removed?
okay. Let's see. We've got you saw two people.
This is I'm looking at the transcript.
Just making sure mine is on part. Yeah, see. Okay, no. Second person count 45. Troy. I think we're just at Matthew Bonnett. So far, nothing consistent. See, and this is where I'm getting it out here, right here. This is the section where it's been removed, Your Honor.
What
Says,
section, sir?
No, I can't. I don't remember. I know at one point a small knife fell. I know at one point another stick fell. I believe that is when Roger got it, but you were talking a year and a half ago, and they are memories that I try to hide, so I can't answer that honestly.
Why do you say that's been removed?
Because I don't see all of that there.
Well,
I mean,
I don't know.
maybe the
What
copies-
I've been given, it says
Hey,
the whole
JC.
page.
Good morning.
I'm
Good
looking
morning.
at it,
Good
Your Honor.
morning.
Goes page 14.
Oh, you know what? Hold on. I may be mistaken. Hold on a second. Page here.
Just a really quick FYI, got to start watching for kiddo to get off the bus here in a few minutes. So if I just poof disappear out of nowhere, you'll know why. But I will be back momentarily. If they end up going to break before I can get back, then just head over to the snack table, get yourself a snack. Lee put out all kinds of goodies. So, yeah. Thanks, Morgan. It's good to see you back in here this morning, JC. We started a different trial a while ago while they were on another break. Opening statements we were in the middle of in Ohio versus Erica Stefanko. Retrial. This is her second trial. It's good to have you here. Good to have you here. All right, I'm going to resume and mute myself again, and I will be back as soon as kiddo's off the bus.
Let's see, we're at line 20. Check. Okay, I'll backtrack on that, Your Honor. It was my mistake. I was reading the wrong section.
So to be clear, Judge, nothing has been removed.
But let me again check it for inconsistency. So let's see where we're inconsistent here. Because okay, the only thing that I see that's inconsistent with this is that she thinks that at one point where Rory Wilson has the billy club, which again, I don't see how if he's on top of her slicing her throat, she thinks he has a billy club.
Well, Judge, it doesn't matter what he thinks. She said in her perpetuated testimony that the guy on top of her had a knife to her throat and the other guy had the billy club. And here she's putting the billy club in Rory Wilson's hand.
Again, this goes back to state of mind.
Yes, and those are all subjects that you can make closing argument about. The issue would be weight and credibility as opposed to admissibility. In other words, I admit it, but if you care to and you believe that this was she was confused, that her mind had been somehow or other impacted by some other event, or that it's unworthy of belief, that goes to the weight and credibility. It doesn't go to the admissibility.
No, and Your Honor, I would agree, and I'm just saying that she did make those statements in her current state. In her current statement, she said that she was confused by Detective Pitcher.
Okay.
Now, the only other thing, Your Honor, actually, let's make sure I'm correct here. No, go ahead. As far as that section, I have nothing else, Your Honor.
Page 15, lines 1 through 25.
Judge, before we do that, so on page 14, is this court ruling that the state's allowed to introduce those statements?
Yes.
Okay.
Any objection to this page?
Your Honor, quite honest, I'm trying to remember exactly what Ms. Belmont said in her perpetuated testimony as far as the altercation. I'm not sure if it's, I can't honestly be sure if it is or it is.
Well, let's hear what the state's explanation is or argument.
Very well. Page 15, she clarifies who was in what position. During her perpetuated testimony, she was all over the place about who was where and who was doing what. So here she somewhat clarifies that when Matt came up the stairs, Rory was behind him and who was facing Rory when he came up the stairs, et cetera, et cetera. So she clarifies a lot of where she was on the perpetuated testimony, which was all over the place on who was where on the inside. She also clarifies about there being a small knife that fell. She wanted to get it.
Your Honor.
Yes, sir.
The small knife is in reference to a knife that Roger Ruggett had, and yes, you did try and go after.
And I'm back. Not yet. The kiddo, I just got a message from the bus saying that they were running a few minutes behind. So they should be here in the next few minutes. But anyway, I saw Steph's comment saying dishes are done. Can we just move to the, oh, hold on, my plastic on my diamond painting is messed up. Dishes are done. Can we just call this case a bust and move to the pizza delivery one? That's what we're gonna probably end up, because they're breaking these days up left and right. This day is gonna be short for them. They're not even having the jury come back till 1 o'clock today. So when they're done doing what they're doing here and getting things figured out, then we'll go back on over to the opening statement. So yeah. Um, um, does Tucker even have a microphone? He does. He just won't use it. He's sitting down and not even speaking into it. I know. Yeah. Gosh. Yeah, this is a waste of time. I just want to see what they decide, but we can skip all the bull poop. Right. So that's what we're gonna um I just want to get to the stuff, get to the meat and the potatoes. All these little bits are not meh. So it's just annoying. Um JC said, only Steph, I'm sorry. I was helping out my aunt and was busy and worried. I should have let you guys know. Sorry, crime family. That's okay, girlfriend. We were worried about you though. Um Finally I was like, you know what? I think I can tag her in a comment. So I went back to find one of the videos that you had left an actual comment in the comment section and not just in the chat part. And that's where I tagged you in a comment, a reply to a comment. I'm like, girlfriend, we miss you. Maybe me and JC are two personalities of the same person, said Steph. You don't have to apologize. We were just all super worried. Yeah. JC, in the back of the day, you weren't here, Tammy said. So, okay. I'm going to go ahead and mute and let this play. You all can just listen to them argue a little bit more. But then, when I get back from getting kiddo off the bus, which will be here any minute, then I'll have to get him situated with a quick bite, usually a sandwich and chips, and um, then we'll get back in here and get back to this opening statement for the other one and see if we can find out about day one, start their witnesses or something. So yeah. All right. I will be back in just a few minutes, guys.
I don't see where that, again, I don't know where that's going to come in as inconsistent. But as far as, being all over the place, again, she seems to be all over the place in here too, as I'm reading it. Or maybe I'm reading it wrong.
Well, I would agree with you there. Is there an objection or no?
The only objection you can get from me, Your Honor, is I don't think it's inconsistent. I mean, she's all over the place. I can barely keep up with, I'm trying to picture in my head what happened here. And, again, it is all over the place.
Well, yeah, I mean, Mr. Mansfield, unless there's something specific, it's really just hard for me to be able to pigeonhole this into a prior inconsistent statement. It seems, it just seems too broad to me.
Fair enough.
I would incline to sustain the objection.
Okay. Judge, and that was it. It was just basically lines 12 through 18 about who was where coming up the stairs and where was the information Matthew Bonnett, but it is vague and that's fine. I understand. I won't use 15.
All right. So now we're on to 16, lines 13 through
25.
25. Mr. Tucker,
I'm looking at it again, Your Honor, because this would be one of those where I was talking about lines being cut out. Because it is starting off at 13.
yeah,
And I just want to make sure that there's nothing that adds context, before that or after.
well, there's nothing special about the pages. It's not like they're organized by,
That's all.
they're not organized by subject matter. They're just, chronological recordation or transcript of what was said.
Line 13. If that's not inconsistent as far as the littler person, dark clothing, it's not inconsistent. Okay, this is what, okay. Yeah, so you heard the second person speak. Yes, I think we killed him. That's what I heard him say. What I would ask the prosecution, what's inconsistent?
Judge, what's inconsistent is right at the beginning, I couldn't see the second person hardly at all, except he was the littler person. And in her perpetuated testimony, she's giving these statements about being 100% sure it's not Tyrone. It wasn't his physicality. It wasn't his stature. It wasn't his walk. It wasn't his persona, whatever. She went on a whole litany of explanations. But the truth of the matter is, here in this depo, she says, I couldn't see the second person hardly at all. In her perpetuated testimony, she was adamant it wasn't his walk, it wasn't his this. It's completely contradicting what she testified to.
Your Honor, if I
Yes.
may.
Mm-hmm.
Again, I don't see it that way because, okay, she does say that she has trouble seeing him because, Rory Wilson's on top of her and she only sees parts of it, parts of it. She actually later on goes to say in this one that their best view is when he actually goes down the stairs. Now, at that point, she definitely can see size, and she does say that he's smaller than Rory Wilson. She repeated that many times in the perpetuated testimony. Again, again, I don't see where it's inconsistent here. I mean, it may be a little bit, again, maybe, I don't know, confusing, but it's not inconsistent.
Well, did she ever say definitively who among those two people said, I think we killed him?
She thinks the second person said that, but she said here that she barely saw the second person and she heard the second person say that. In her perpetuated testimony, she was adamant the second person was not Ty Tucker.
Well,
Well, she doesn't say specifically in this that it was or it wasn't. It's not inconsistent. She just doesn't say it. She doesn't mention it.
Well, I think that the statement, I couldn't see the second person hardly at all, except he was a littler person. I think there's an inconsistency there in terms of one's ability to be so adamant as to who it's not. Now, if you want the rest of this stuff carved out, I might be inclined to do that, although I think this is precisely what you were concerned about, Mr. Tucker, as to context.
would agree. I'm looking at it right now. I'm just trying to figure out context right here. It's like, okay, because I know she makes other statements, and I haven't, Your Honor, I did not have enough time to go through the deposition in its entirety. I'm happy we're doing it now, but so I haven't had a chance to look at the entire thing. But I do know she goes into it later, where she's talking about, again, she sees different details. Just because she only, they pick out one detail here doesn't mean she doesn't, say other details in another section.
Well, in any event, I don't understand why this business about Todd O'Quinn at the end is in there.
I can take that out. Judge.
I mean,
Again, it was for context, but leave it in there. Take it.
well, so line 13, okay. Okay, line 14, line 15, line 16.
I think I would object to those, Your Honor, just because she doesn't say who says it. Like, she doesn't say that it was, she doesn't actually get asked whether or not, she recognized the voice, anything like that.
Judge, I would propose that we potentially cut it off at line 18 because that's the sum and substance of the identification.
All right, so
So we're just going to go from 13 to 17, is that correct?
18.
To 18.
18 answers the
Okay,
question.
yeah, I mean, that would be
All
fine.
right,
That would be fine, Your Honor.
so now we're on page 17, 14 through 25. What about this one?
Okay, this would go back to that whole picture thing. Because yes, he does confuse her and has her at a point where she says that it's not inconsistent with what she said in her perpetuated testimony. She says specifically that picture confused her about things. And she says right here that she is confused.
Where does she
Well,
say?
I mean, she's not saying specifically she's confused. What she's saying is, no, because I didn't know he had anything to do with it. Or if he had anything to do with it, I didn't know what they all lived together. That was being perpetuated to her by Pitcher. And, again, he specifically sat there and told her, Ty Tucker did this, Ty Tucker did that. Ty Tucker, has a long rap sheet. Ty Tucker has all this other stuff. And he's literally pumping her full of it. And
So
she says that. And she says that it confused her.
where's the inconsistency here, State?
Judge, during the perpetuated testimony, she talked about knowing that it wasn't Ty, that Pitcher had told her, and she kept saying to Pitcher, are you sure? Are you sure? Because I don't see it. I don't see it.
That's
And
why-
here she says, didn't you tell him at the time that you knew he had nothing to do with this? No, ma'am, you did not know, because I didn't know he had anything to do with it, or if he had anything to do with it. I didn't know that they all lived together.
And, Your Honor,
So wait, just let me ruminate on this a second. So what is this inconsistent with?
During the perpetuated testimony, she articulated that she knew it wasn't Tucker that was the second person. That is not what she's saying here. Here she's saying that I don't know if it was him or not. I don't know if he had anything to do with it or not at that point when they met at McDonald's. In the perpetuated testimony, she was adamant that he wasn't the second person.
Your Honor, if I
No,
might.
the defense argument is.
Yeah, the prosecution just made it for me. He literally just spit back what Pitcher was telling her. You know, and again, he's sitting there telling her, she's like, are you sure? Are you sure it wasn't Ty? You know, and he's feeding her a bunch of stuff that says it, you know, says her memory is wrong. And later on, after she found out the picture was lying, yes, it solidified her memory.
Judge, she can argue all day to the jury about what picture put in her head, but this is an inconsistent statement from what she made in her perpetuated testimony.
That's why I say it's unfair to put it out of context when she says that happened, and yes, we know it happened. You just repeated it, but you want to use the section where she was being confused by him.
Was he, I'm sorry, I mean, obviously he wasn't the deponent here.
No,
so-
no, he literally pulled her in the squad car, I don't know how many times, and literally sat there and said, it's Ty Tucker, it's Ty Tucker, it's Ty Tucker, over and over and over again.
Well, I mean,
And then blatantly lied to her about a whole bunch of things. And she kept on going, are you sure? I don't think it's Ty. I don't think it's Ty. You know, and she's saying, are you sure? And she is obviously confused by the guy. And she says that in her perpetuated testimony. She, you know, again, there's nothing inconsistent. She says at one time she was confused.
okay, so maybe this was one of those times, but nevertheless, it's an inconsistent statement, so I'm going to overrule the objection. So now, page 18, lines 1 through 25.
Your Honor, I mean, just a quick objection here. I mean, this is one of the ones where I say taking the sentences out of it definitely changes the context.
What sentences are taken
Well,
out of
okay.
it? I see 1 through 25 as what the state's.
Yeah, I'm looking at it. I'm like, okay, let's see. Hold on. No one after. Okay, police didn't tell you that. She goes, who told you that Ty had something to do with it, right? Let's go back here. Nobody told me. Police didn't tell me. No. Well, afterwards, when they arrested him, yes. You know, so and that you know.
It's not removed.
I'm
It's
sorry.
right there in
Sorry.
I would assume you would.
Sorry.
You would want that based upon what you've
Okay,
wrote.
not afterwards arrested. Yes, okay. Nowhere near him. That's true. Oh, and again, I'm looking for inconsistencies here because there's nothing inconsistent so far. All right. Are you sure that was involved? What kind of question is that?
Ah, back. It is so nasty and cold and wet and rainy outside. It's disgusting. So, okay, you guys, what is the consensus? Phew. Kids are the best PETAs, pain in the arsenals in the world. They are. They literally are. Steph, should I be reading that as I was pooping earlier, so I can't judge? Or should I be reading that as I was pooping earlier, so I can't judge?
This is actually hearsay too, by the way.
Sorry, I thought that was funny.
Because
I thought that was funny.
I'd be happy to clarify what I said in there, but
Mm.
you know, you're taking my testimony and putting it in there.
Well,
All right, so here are my thoughts. My thoughts are let us, let me start another live so that I can, like Steph said, title it. And then, as much as I hate to, I would really need to replay the opening statements again. I know we just watched like the prosecution's defense and then most of the or part of the defense's opening statements. But if if somebody, say 6 months from now, decides that they want to watch this trial and they randomly find it on my channel, because I'm all that a bag of chips. But anyway, totally kidding here. Totally kidding. But let's just say that happens and then they're like, okay, well, where's the opening statements? That's not in here, especially if it says day one, right? So I think that would be better. Uh Henceforth you shall be known as Judge Jenny. Yeah. Whenever I started this channel, I did pop around with the idea of I thought about calling it Judge Jenny, like Judge Judy, but then I was like, don't be a judgy Judy. And then I thought about calling it Judgy Jenny, but I'm like, that's a mouthful and a half. So yeah. Uh I've been trying to start that trend. I'm her court reporter, says Steph. Morgana says, well, what am I then, Steph? Morgana the bailiff. We should go back and tell them that this case is a waste of time in the comments of the first one. Right? So, yeah. JC says, I like Judge Jenny. All right. I'm going to exit this one, stage left, right, and center, because Hoop Show day number 8, right? I'm going to do that. I'm trying to get a headache, and I don't want a headache. So, JJ for short, says Morgana. I agree, Steph. Judge is being biased. Tammy thinks so. Tammy's been saying that all along, that she feels like the judge is being biased. So it is currently 11:54 a.m. Oh, I know, right? JJ Vallow every time. Oh, goodness gracious. Poor sweet baby. Headache, go away. Yeah. And don't return any other day. So I'm going to go ahead and close this out. It's 11:54 a.m. Eastern Standard, and then I'm going to restart a new stream with this other trial. Now, the only place that I have found it is on Court TV, but there is another news station. I'm going to look and see if I can find the actual court streams, because Court TV can kind of be a little bit meh about sharing their stuff, even though it's like these courtroom proceedings generally are not like copywritten material, even though it's from Law and Crime or Court TV, because they're media pool cameras. So because multiple people have access to them, there's not any one copyright on live streamed trials, usually. But still, I'm going to see if I can find the right stream. So let's resume this. It's 12 o'clock now. Let's say 1 o'clock. That'll give me an hour to get a bite of something to eat. That might help my headache go away. Jolie's going to be wanting something to eat soon too, and my hand is itching. What does it mean when your right palm is itching? What does that mean? Somebody tell me. So let's say 1 o'clock, okay? Meet me back here at 1 o'clock in a new stream, all right? Guys, all right, all right, all right, all right. Money, does that mean money? Coming into money, all right. Good deal, I like that. I like that a lot. All right, you guys give this video a thumbs up, even though it deserves their video. Their trial deserves a thumbs down, and we over here deserve a thumbs up for trying to stick through this mess. But I will keep an eye on it, and if anything funky or cool happens, like if they get in a big fist fight or something right in the middle of the courtroom, then I'll be sure to like save that part and share it on the other video when we're like in a breaking point or a sidebar city or something, you know. Don says someone is going to give you money, coming into money. Steph says bad luck or financial prosperity and blessings. Okay, well, we're going to go with the latter. I'm not going with bad luck. Henny says, okay, see you in a bit. Steph says, let's get Jenny monetized. Yeah. Right? Fight, 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 fight. I would love to see I'd love to see a big fist fight, like a big old bar brawl right in the middle of the courtroom between these guys. That would be the best. The best. All right. I will see you guys back. Thumbs up the video regardless. And I'll see you back around 1 o'clock. Bye, guys. Bye.